Friends, in this module, we will look at the origin of the issue of sexual harassment at workplace in India. That is, how we actually started taking cognizance that sexual harassment could be an issue at workplace as well, and how it eventually resulted in the enactment of India's POSH Act, that is, Prevention of Sexual Harassment Act in 2013. It all began in 1992 in rural Rajasthan. Bhanwari Devi was employed as a Sathin for the state government's Women's Development Program since 1985 and worked in Bhateri village, about 50 kilometers from the state capital, Jaipur. Her job involved going door to door in the village to campaign against social ills and discourage female feticide, infanticide, dowry, and child marriages. During the course of her work, she attempted to prevent the marriage of a 1-year-old girl in the community. Not surprising that her work was met with resentment and attracted harassment from men of that community. Bhanwari Devi was subsequently gang raped by those very men. There was immense outrage in India and globally as massive protests were held in Jaipur with thousands of women marching through the city-states demanding justice for Bhanwari Devi. Based on the facts of her case, a public interest litigation was filed by Vishakha and other women groups against the state of Rajasthan and Union of India before the Supreme Court of India in 1997. The petition proposed that sexual harassment be recognized as a violation of women's fundamental right to equality and that all workplaces, establishments, institutions be made accountable and responsible to uphold these rights. The Supreme Court, in a landmark judgment, Vishakha versus State of Rajasthan 1997, held that sexual harassment at workplace is violative of constitutional rights of women, including rights of equality, to practice any profession and to right to life with dignity, and therefore it is discriminatory towards women. In the absence of any law at that time providing measures to address sexual harassment of working women, the Supreme Court stated that an effective alternative mechanism was needed to prevent violations of these fundamental rights in the workplace. In order to fill this legislative vacuum, the Supreme Court in the same case created legally binding guidelines on the prevention and deterrence of sexual harassment in the workplace. These guidelines raised the bar of responsibility and accountability by obligating the employers to uphold the working women's fundamental right to equality and dignity at the workplace accorded under the Constitution of India, Article 14, 15, 19, 1G and 21, as well as by the provisions of the UN Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. The Vishakha Guidelines, as this is popularly known, were to be treated as law declared under Article 141 of the Constitution and were to be applicable until relevant protective legislation was enacted by the Parliament. It was very comprehensive and included definition of sexual harassment, preventive steps, criminal proceedings, disciplinary action, complaint mechanism, complaints committee, and workers' initiative. The most important aspect of the guidelines were it extended to all kinds of employment, from paid to voluntary, across the public and private sectors. It put the onus on the employer to prevent the commission of acts of sexual harassment and to ensure that women did not face a hostile environment. The employers were directed for the establishment of redressal mechanism in the form of complaints committee which will look into the matters of sexual harassment of women at workplace. The complaints committee were mandated to be headed by a women employee with not less than half of its members being women and provided for the involvement of a third party person, NGO expert on the issue to prevent any undue pressure on the complainant. The complaint procedure should be time bound, and the guidelines also prohibited intimidation or victimization of the affected complainant, witnesses, and those cooperating with the inquiry, and maintenance of confidentiality of the victim. The Vishakha guidelines imposed three key obligations on all institutions, namely prohibition, prevention, and redressal of sexual harassment at workplace. The National Commission for Women, a statutory and autonomous body constituted by the Government of India to secure justice for women, took up as the focal point the issue of sexual harassment of women at workplace in 1996 and pursued with the various central ministries and departments in an effort to promote the well-being of all women employees at the workplace. The National Commission for Women in 1998 formulated a code of conduct for workplace based on the Vishakha guidelines and circulated it widely among all central ministries, government departments, state commission for women, NGOs, and apex bodies of the corporate sector and to the media. The need for legislation on sexual harassment of women at workplace was long overdue. The very first efforts towards enacting a law for protection of women from sexual harassment at workplace were taken in 2007 when the Protection of Women Against Sexual Harassment at Workplace Bill 2007 was introduced in the Parliament by Women and Child Development Minister Krishna Tripathi. The bill was approved by the Cabinet in January 2010 and was placed in Lok Sabha in December 2010. It was subsequently referred to a Parliamentary Standing Committee on Human Resource Development for examination. Further to the report of the committee, subsequent changes were made to the original bill, including the title of the bill, which was changed to Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Bill 2012. Clearly, the focus was not just on redressal of complaints of sexual harassment, but also on the prevention and prohibition of sexual harassment. Subsequently, on 3rd September 2012, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Bill 2012 was passed into a law by the lower house of the Parliament. It was further confirmed by the upper house of the Parliament on 26 February 2013 and received the President's assent on 22 April 2013. The Act became effective since 9 December 2013. Finally, 13 years after the Vishakha guidelines, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 was enacted. Consistent with the Vishakha judgment, the Act aspires to ensure women's right to workplace equality free from sexual harassment. The Act makes it mandatory for every employer to provide mechanisms to redress grievances pertaining to sexual harassment at workplace and enforce the right to equality of working women. Bhauri Devi might not have any direct role in this law, but undoubtedly she has been the catalyst, the main factor in its enactment. Her experiences revealed the ever-present sexual threat to which millions of working women are exposed to across the country, everywhere and every day, irrespective of their location. It also shows the extent to which harm can escalate if nothing is done to check sexually offensive behavior in the workplace. So, what is this law exactly? The first part of the law describes in details what constitutes sexual harassment at workplace. We have already discussed this at length in Module 1. So, here let's look at the other aspects of this Act in details. Who is covered by the Act? And aggrieved women. The Act recognizes the right of every woman to a safe and secure workplace environment irrespective of her age or employment or work status. So, an aggrieved woman can be a student, can be a domestic worker, can be a daily wager, can also be a contract worker, a trainee, or a probationer. Where is the Act applicable? The workplace. A workplace is defined as any place visited by the employee arising out of or during the course of employment, including transportation provided by the employer for undertaking such a journey. As per this definition, a workplace covers both organized and unorganized sectors. In the digital age, this definition can be expanded to include telephone conversations, texts, and messages on social media. Who is responsible for making the work environment non-hostile? The employer. An employer is defined to mean any person responsible for the management, supervision, and control of the workplace and management, including the person or board or committee responsible for formulation and administration of policies for such organizations. What is the responsibility of the employer or the district officer? Primarily prevention and prohibition. The employer must create and communicate a detailed policy, must ensure awareness and orientation on the issue. The employer is required to constitute internal complaints committee at every office of the organization or institution having more than 10 employees to hear and redress complaints pertaining to sexual harassment. The committee, while inquiring into such complaint, shall have the power as same as vested in a civil code. The employer must prepare an annual report and report it to the respective state government. Where the number of employees are less than 10, setting up of local committee in every district by the district officer is required. The district officer will also appoint a nodal officer to receive complaints at the local level. So, what is the complaints mechanism that is provided in the Act? The POSH Act provides for two kinds of complaints mechanism: the Internal Complaints Committee and the Local Complaints Committee. All complaints committee must have 50% representation of women. Both ICC and LCC members will hold their position not exceeding 3 years from the date of their nomination or appointment. What relief can be given to the aggrieved women? Under this Act, the internal committee can recommend to the employer to provide relief ranging from transferring the aggrieved women or the respondent to any other workplace, grant leave to the aggrieved women up to a period of 3 months in addition to the leave she would be entitled otherwise, and to restrain the respondent from reporting on the work performance of the aggrieved women or writing her confidential report and assign the same to another officer. What happens if the respondent is found guilty? Punishment can range from disciplinary actions including a written apology, reprimand, warning, censure, to withholding promotion, pay raise, increment. It can also result in termination, counseling, and community service. Financial compensation may also be provided. What are the penalties under the Act? If an employer does not comply with the POSH law, they can be penalized with a fine which may extend up to Rs 50,000. On repeated non-compliance, the employer may be penalized with twice the punishment. Non-compliance can also lead to cancellation of license, withdrawal, or non-renewal of registration for carrying on business by the government. It is important to note that the Act provides a civil remedy to women and is in addition to other laws that are currently in force. Consequently, any woman who wishes to report instances of sexual harassment at the workplace has the right to take recourse to both civil and criminal proceedings. It must also be remembered that the offences under the POSH Act are non-cognizable, which means that one cannot be arrested under this Act without a warrant. What are the rights of the complainant? When it comes to redress for workplace sexual harassment, the complainant has a right to expect a trained, skilled, and competent complaints committee, a time-bound process, information confidentiality, assurance of non-retaliation, counseling or other enabling support where needed, and assistance if she wishes to opt for criminal proceedings. What are the rights of the respondents? Although understandably the majority of rights lie with the complainant, a respondent who feels wrongly accused is entitled to a patient hearing to present the case in a non-biased manner, a copy of the statement along with all the evidence and a list of witnesses submitted by the complainant, confidentiality throughout the process, and right to appeal if not satisfied with the findings of the internal committee. What is the sexual harassment complaint process? The process consists of 6 stages starting from the receipt of the complaint, proceeding to planning carefully, conducting interviews, reasoning, finding and recommendation, and finally reporting. The internal committee, before it initiates inquiry, may try to reconcile between the parties if the aggrieved women request so. But monetary settlement cannot be the basis of conciliation. If conciliation is not possible, the internal committee will inquire into the complaint and give both parties a chance to be heard and complete the inquiry in 90 days' time. During the inquiry process of being heard, neither party will be allowed to bring their lawyer. Post-inquiry, the internal committee will have to prepare an inquiry report giving recommendations on the matter in 10 days and give a copy of the same to the organization or company concerned and the concerned parties. The company or organization will have to act on the recommendation in 60 days' time. The Act also provides that if a victim is dissatisfied with the findings of the internal committee, she can appeal to a court or tribunal. In addition to registering a complaint of sexual harassment with the internal complaints committee, the aggrieved women can also file a complaint with the Ministry of Women and Child Development at its portal shebox.nic.in. Friends, this is the portal of the Ministry of Women and Child Development. An aggrieved woman can also file a complaint of sexual harassment here, the Register Your Complaint section, and can also view the status of their complaint here. How to file a complaint has been detailed out in this tab, and here is the step-by-step process to register the complaint. The portal also has a section of frequently asked questions, FAQs, and this section deals with more or less the most of the issues that is faced during filing of a complaint and other issues related to sexual harassment. So in addition to filing a complaint to the internals committee of the organization, an aggrieved woman also has the option of registering a complaint with the Ministry of Women and Child Development. In the next module, we will specifically look at the issue of sexual harassment in higher education institutions and what has been the response of the University Grants Commission, that is the UGC.